It's our position, Your Honor, that the court psychiatric record was improperly released, that it is not a public record. We would like to have a hearing on this particular issue. At least two media outlets have had access to the report. The Plain Dealer, you addressed that last week, Your Honor, but it's also part of our motion that at least one of the television stations has a copy of the report up on their website, and it's available to the public. We think that's improper because this is not a public record. In fact, as you may recall, Judge, I tried to obtain a copy of the report with a signed release from my client, and the clinic would not give it to me. I had to come and get an order from this court. And I think it's very curious that the Plain Dealer reporter who evidently looked at the report through Judge McGinty didn't get it through the clerk's office, which is the keeper of the court's records. They didn't get it through the court's psych clinic, where it was originated from. They had to go to an informant to get it. So that speaks volumes to me.
It was a report generated by the psychiatric unit to help the court back in 2005 determine whether or not this guy over here should be labeled a sexual predator. That's all it was used for. It is a public record. This report was admitted into evidence back in 2005, and actually the report worked to his benefit because he was not labeled a sexual predator. What does this have to do with their ability to defend Anthony Sowell against the accusations in this case? It has nothing to do with evidence in this case. It's a sideshow, and I'm asking this court to put a stop to it now and deny the request for a hearing. Thank you.
If we have a hearing, what would be the purpose? I mean, we understand that the information was released. We differ, you two differ about whether or not it was confidential or whether or not it wasn't. But if we had a hearing and I made a determination, then what? You know, he isn't prejudiced by it. So then if we make the determination that it was confidential or it wasn't confidential information, then what?
Your Honor, that's a very good question. And our answer is it's still out there on the internet. People are looking at it. People have access to it. It's going to make it more difficult to select a jury in this community if they have access to this report, which they may or may not get throughout the course of a trial. And we think there's information in there that's prejudicial if they do review it. So it's going to impact.
It's on the internet. It's available for the world to see.
Exactly. And if
so we can't move it out of the world.
No, but you can order the local media to withdraw from their internet website in an attempt to get a fair jury in this case.
I think that the public has a right to know about these trials, but I've just come to find out that the Plain Dealer is trying to further intimidate me and do other things to me as a result of this yesterday, and I was interviewed by a Plain Dealer reporter with reference to it this morning. I'm thinking seriously about conducting this trial without media present. If it interferes with Mr. Sowell's right to a fair trial, then I'm thinking about when I think though about the public's right to know, they have a right to know. They have a right to see what's going on, and this is going to be a case that people are going to find very interesting and want to know about. But in your requests that I order them to take it from the website, that's going to cause another side issue that's going to distract from the progress of the trial. You're going to be preoccupied with it, you'll be preoccupied with it, and then we won't be focused on proceeding to trial, which is what I want to do. I want to go to trial on June 2nd. So if I get into this other situation, then it's going to cause us all not to focus on the trial. So we have a situation where the media is actually entering into a phase where it's starting to interfere with the progress of the trial, and I don't want that to happen. I will tell you what, Judge Russo has a question that she always uses in her voir dire, and that question is, where does the jurors get their information? Where do they gain their news? And I think it's a very good question in terms of voir dire. What I will allow as a way of compromise to help us to obtain a fair and impartial jury is that question be, if you want to voir dire on that question, you can. I just don't see, ordering somebody to take a site down, having to have a hearing on it. That would just blow it up further. That'll make it a bigger than life production. They're going to take steps to protect themselves, and they're going, the plain dealer is already personally attacking me and, looking at me and all my family background and the whole thing. It's just too much. All we want to do is get this man a fair trial. I don't think that it prejudices the defendant. I find that it is not a public record, and I rule as a matter of law that it is not. The case law has indicated that these records are not public. I think the waiver that is signed by the defendant is one that is signed so that it's explained to the defendant that the material and the information he provides will be forwarded to the court whom is hearing the case. What I will do today is ask the media to please keep in mind that this is a trial. We're trying to give him a fair trial. I would ask you to exercise caution, to be thoughtful in your presentation, and to keep in mind that while we understand that you have an interest in informing the public, that the court has an interest in bringing Mr. Sowell to trial with all of the protections and the guidelines that exist in each case. I don't think that his right to a fair trial has been damaged. I don't think that we're going to be, I think we'll be able to pick 12 people from the public to hear this case. 12 fair citizens to listen to this case, and we'll get 4 alternates, and we'll be able to proceed.